far as this PowerPoint goes, Mary, if you want, I can get it to you. And if anybody that's participating wants a copy of it, they're certainly welcome to it. Because what I've tried to do is go through some topics and then put different examples of different documents, what they might say, because even on tonight, there'd be 10 or 15 people that are listening, and the answers might not be the same in one association to another based upon what their documents say. And so if this will be useful, Mary, you're welcome to use it as you and the company see fit. So
that's great. And for all of you that that might not have gotten the message, I don't know if I had sent it out or not, I don't remember, but we are recording this on the Zoom, saving it to the cloud. We're hoping it all comes out okay. And then if it does, we're gonna create a YouTube video and put it on our website. So for those that could not attend tonight, they'll be able to go in and view it. And for those of you who want to refer back to it, you'll have the video on there as well. Okay, so again, I'd like to thank John for joining us this evening to do this class for us. I don't know if you've all heard John speak before, but he's amazing. And I know that you're really gonna enjoy this presentation. He's very thorough and he's a great speaker, and we really appreciate him taking time out of his busy schedule to join us this evening.
well, thanks, Mary. I appreciate that those kind words. It's funny because I always look at YouTube as the way you never get to forget your mistakes, because it's out there, man. No matter what you do, man. It's
well, let's review it first, John.
I was gonna say, oh my goodness, these poor people, they get tortured. They get to see me. I get to make my mistake 100 times. But no, I appreciate that, and I hope this is useful. Mary just told me, and we talked a little bit about architecture review. And so what I did is, and we'll go through this, is come up with what frequently some of the most common issues that are out there, and then take examples of different CC&R provisions or statutes that are relevant, so you can see the different interplay. And I think more than anything else, at the end of the night, maybe the most important message is you really got to be familiar with your own CC&Rs, because like I said earlier, with the answer to one might not be the answer to another because your documents are different. But we'll try to look at some of those differences. And as I said earlier, if you have questions, please feel free to ask them when we're on the subject rather than waiting to the end. I don't know about you, but sometimes I like to have the context in which the question is being asked. And so that might be better. And like I said earlier, I won't be offended if anybody wants to unmute to ask a question. I just say that if you do unmute, then after you ask your question, put it back on mute, just so that there's no noise in the background, stuff like that, so the rest of the people can hear all right. So anyway, I appreciate your willingness to do this. First, a great thanks to Camco. And I think you learn from this type of experience how education is important to this company. Many years ago, this wasn't something that happened, but nowadays, Camco has a phenomenal education program where they reach out to their board members and try to provide them with education that'll be useful for them. And they do it based upon requests from homeowners, their experience in board meetings, and just what's going on in the marketplace. So Mary, please make sure that Joel and the rest of your Camco team know how much we appreciate the fact that you continue to do these kind of educational classes.
Down a little bit. Twice. I didn't know it was out there.
Okay, I'm sorry to interrupt you here, John. For those of you who have just joined us, if you wouldn't mind, please putting your volume on to mute. You can find that under the video button, and then you can unmute yourself if you have a question as John's going through the program. Thank you so much. I see a couple of people on here that we're still need to mute. So if you could please go ahead and do that right now, we would appreciate it. So
Yep, perfect.
you, Veronica. We have a phone number of 801 starting with 556. If you're on there, can you please mute yourself?
Yeah, I'm actually on the phone and my phone is muted. I can't mute it on the screen. This is Lance Lee. I'm
Okay.
on both via
Perfect.
phone and
Okay,
Zoom.
as long as that other one's muted. Thanks so much. And how about L. Hogan?
My phone is muted.
Okay, I have a Lisa and I have an L. Hogan. Are you L. Hogan also, Lisa?
Yeah, I'm sorry. I'm having problems with my computer too.
Okay.
I can relate to that kind of stuff.
Okay.
So
All right.
whatever you need to do, you just do it.
Yeah. Okay,
Anyway.
thank you so much. I'm gonna mute myself too, because I have a 2-year-old grandbaby outside my door who wants me right now. So I'm
All
gonna
right.
go ahead and mute myself.
So what from your experience, all you wonderful board members, for your goodness and your service, what are some of the more common difficult issues or some of the challenges that you see in the architecture review area? Please feel free to hit the old type them in, or if you want to unmute and say something, please feel free to do that. Just like to get, you can put it in the chat or whatever. The common problems that you're seeing in your association or that you've been experiencing, anything like that.
This is Lance Lee. In our community, we've had a number of ARCs and middles come in, and they're very incomplete. And it's just the process of getting them feedback and trying to get them to comply. That's one issue that we always have. The second is, in our community, we don't allow certain things like dumpsters in the streets and things of that nature. And no matter if we put it on their approval that you can't put them on, they're putting them in the streets. And it kind of drives us a bit crazy.
Okay, good. So incomplete architectural applications is one, and the second one is just after you give an approval or even a conditional approval, they're not necessarily following those conditions. Yeah. Okay. Anyone else want to share some of the issues you're having?
I would agree. Our community is a newer community, but same thing. A lot of the architectural review, it's all done online, but I'll notice the same thing. I'm sure our other board members are on the call too. A lot of times you'll get an incomplete. So then you have to go back to them, and it's like a lot of back and forth, whereas, you know, it delays our response to them. And same thing, in our community, you're not supposed to like dump materials in the street. You're supposed to put it on your driveway, but everybody inevitably dumps their rock on the street or their materials on the street.
So it sounds like in one instance, we have problems at the inception of the process, but we also have problems while the construction is going on, that the manner in which they're doing the construction isn't consistent with the conditions, or in fact is being done in a way that can actually create damage to our streets, interfere with other people's ingress or egress to their units, and things like that. So those are, I just made this list, and believe me, you guys you do a better job when you share with me the things that are going on there. But I've been practicing law in Las Vegas since 1985 and working with associations over 35 years. And you would not believe the range of ARC problems that are out there. So I just made a list, even the creation of an ARC, or who are the members of the ARC. The homeowners that want to rather ask for forgiveness than permission. So they go ahead and do whatever they want. And then they come back and say, oh, I'm really sorry here. Just stamp your approval on this. Sometimes we have timeline issues where if we don't act in a timeliness pattern, then the application becomes admitted or approved. There's issues with neighbor awareness or neighbor approval. And then there's also confidentiality. A lot of people don't understand the confidential nature of this type of thing. So these are just some of the things that I came across. And we're just going to start going through this thing. I don't want to say from beginning to end, but you're kind of going to see that there is kind of a method to the madness, so to speak, tonight. We'll start with the beginning with oops, I don't know what I just did. There we go. But let me see if I can get it back down here. So is the Architecture Review Committee mandatory or discretionary? From your experience, is it mandatory that the association have an ARC, or is it a discretionary committee? Any thoughts on that?
I know in our community, it is mandatory.
Okay, good, Lance. Thank you.
Ours is mandatory.
Mandatory.
You know what's interesting, folks? I don't know if this is true, but if you go through most governing documents, the Architecture Review Committee is one of the few committees that is actually referenced in the governing documents. The bylaws might talk about, or even the Articles of Incorporation may talk about, hey, the board has the authority to do committees, but it doesn't necessarily name them. But the ARC is almost always identified right in the association's governing documents. In fact, I'm going to just give you a couple of examples. So here's one. First, let me just show that Nevada law. Now, this is the nonprofit corporation law. So this isn't NRS 116, but it specifically says the board may designate one or more communities which have and may exercise the powers of the board. So it's a may is discretionary, it's not shall. So the general corporate laws would say, hey, you can have committees, don't have to, but you may have them if you're interested. But here's an example from a set of CC&Rs. And I just lifted this, so please forgive me. All I did is I randomly went to a handful of different CC&Rs that we have and pulled some relevant provisions so you can see the differences. But this one says, as many do, no construction, alteration, modification, reconstruction of an improvement in the property or other activity within the jurisdiction of the ARC shall be commenced until, and it says, you submit and ultimately you approve. Well, that I think supports the conclusion that it's mandatory, because there's going to be construction activities that go on. And I think, Debbie, I think you mentioned that in your association, it's kind of a new association. And it's when associations are new, you actually see more ARC stuff at the beginning because the homes are brand new, people are moving in, they want to make those adjustments. Maybe they're doing a room added, maybe they're doing something added. And so you'll see a lot more of this. But if no construction can be done without submittal to the ARC and approval by the ARC, then to me, that is mandatory. And this is just another set of CC&Rs, different association, same thing. No structure can be placed, erected, or installed except, and it talks about all construction activities being in compliance with the guidelines. So even if your document doesn't say, oh, the ARC is mandatory, the functions that are performed by the ARC are almost always mandatory because it's something that's going on almost throughout the entire lifetime of a community, maybe a little more at the beginning, but almost always. So where would I find the purpose of the Architectural Review Committee?
I believe ours is written in the CC&Rs to start with.
Excellent. Anyone else have experience with that, or you've seen something that specifically talks about the Architectural Review Committee's functions or purpose?
Ours is in the CC&Rs too.
Yours as well? Thanks, Patrick. So
Part of our issue, John, was we're a new community, and our ARCs were so broad. It was really difficult to have much enforcement in the beginning because it didn't really cover a whole lot of anything, right? And so as we went along, we kind of wrote our own version of guidelines, and ended up actually creating a document out of them. But in the beginning, someone could take issue and say, well, when I bought this piece of property, we didn't have all these rules in there that you now have. And I worry about that a little bit because some people do things with like certain lights. And if you read the description of the light, it actually calls it a landscaping light, but some people take exception with the style of that light. And so, it kind of goes from really broad to really specific in a hurry if you're trying to, keep something from happening.
that is a great observation. If we just go back to those slides that we're talking about, let's go back to the one before that. No construction. So that means, think about it. It says no alteration, no modification. So if I want to put security cameras on the outside of my house, or I want to, like you said, you want to make these what you might call minor modifications, but under the CC&R, we just have this big, broad declaration. You can't do any of these things without ARC approval. And so what you end up doing with time and experience, what you said, Patrick, is you start refining them down to give them more direction, more specific guidance, so that it's easier for the homeowner to know and to predict what's going to happen or what they can expect in the ARC process. And if you give them a little more guidance, then you're less apt to get applications that are maybe incomplete or that really don't address enough information for the board to make a decision. So here's an example of CC&R. I think this dovetails nicely to what Lance was talking about. And it specifically says, and this is, again, I wish I could take some credit for saying, oh, what a brilliant bunch of drafting by John Leach. Well, no, this is just plucked right out of a set of CC&Rs. The functions of the committee, and it's talking about the ARC, is to consider and approve or disapprove any plans, specs, or other materials submitted to it for construction. And it's go down to adopt committee rules and development standards. And Patrick was talking about the process by which to get a little more specific, and by adopting those committee rules or development standards, whatever you, or guidelines, however you entitle it. But again, the idea is overall, it's to deal with the architectural review. And tonight we're going to see some real interesting tidbits about the interrelationship or the interaction between a board and an architecture review committee, and some of the problems and challenges that some associations have because of the way that their governing documents are created. So here's again, just an example. This isn't a CC&R, but what I gave this next one was in a resolution. And so maybe Patrick could go back to your situation. Let's just say that our CC&Rs are silent on the subject of what our purpose is or whatnot. It just talks about no construction except. Well, then you can in a board resolution or in your if you do a charter or if you decide to do association guidelines, you can actually put in a paragraph that describes what the functions are. And again, this one kind of is very similar, and it says you can consider and approve or disapprove plans and talks about the adoption of rules. But this is not in a CC&R. This is language taken from a board resolution, so that when the board adopted their own guidelines, they adopted that language. Who can serve on the ARC? Are committee members required to be homeowners?
I would say yes.
Okay. And you're going to find out that John Leach's favorite answer to every question, I guess is what, maybe it's a typical lawyer, is it depends. And so who can serve on the board? Well, it's going to depend. It's going to depend largely on what do our documents say. So here's an example of one that says the members of the committees need not be members of the association or representative of members. In other words, let's say you have an LLC or a partnership or a corporation that's the owner. In this association, the members of the committee need not be members of the association. Now, that doesn't mean that means that you have to allow non-members to be it, because again, this is the discretion of the board. Who they put on that committee is purely a board decision. And so, but here's this, in this association, it wouldn't have been against the rules or against the CC&Rs to have a tenant serve, or even a third party who doesn't live there, because it doesn't say you had to be a member. And so while that's fresh in your mind, look at this one. Representatives of the committee, this is the ARC, appointed by the board, shall be members of the association. And made in this set of CC&Rs, it made the distinction between the declarant control period, because during the declarant control period, the declarant can appoint people from the declarant company to be on the board. But once you go to transition in this association, the board members must be members of the association as well. So with that in mind, I have a little hypothetical I'd run about. Keep this one in mind. Representatives must be members. So here's a hypothetical. The declarant control period has lapsed. So now we know that the homeowner, the board members have been elected by the homeowners. The board in that association has the authority to appoint the ARC. At the time, there's only one ARC member, and that member is not an owner. It's a former declarant representative. He had actually owned a home in that association for a period, but sold his home. So now at the time, he's the only member of the board, of the ARC. He's not a member of the association. He reviews an architectural application and denies it. The homeowner then sues the association. So what do you think? What thoughts come to your mind in just with those facts?
Well, I think, personally, I think the board was kind of slow at the draw to get an ARC in place, so they're probably responsible.
Yeah, and let's go back. If we look back, keep in mind, there's only one member of the ARC on this, and as fate would have it, this is what their CCNR said. Representatives of the committee appointed by the board shall be members. And so this homeowner sues the association and, oh no, excuse me, he sues his neighbor. Because the neighbor had complained about some stuff. The association had not yet been named as a party, and the judge ripped the association a new one in open court before the association was even a party, saying, well, wait a minute, the CCNRs say that this guy's supposed to be a member. The only representative is this guy. He's not a member of the association. So in other words, the court basically invalidated the board, the process that had been implemented by the association, saying this was inappropriate. You didn't have a valid ARC, so the denial is not legit. There's a time period you didn't do it in a timely manner, and so it created that lawsuit cost gobs of dollars. And as you pointed out, Patrick, a lot of it was they were not prepared to have an effectively performing ARC. And when people left the ARC for whatever reason, they didn't replace them. That association also had a requirement that had a minimum of 3 board members or 3 ARC members. So not only did they not have the 3, they didn't have a member of the association on it. And so the association had a lot of explaining to do in court. And it was a very expensive process for something that didn't really need to be that big a deal. Oh, where's my cursor? There it is. So we kind of jumped on, I kind of touched on this a little bit. How many ARC members are we supposed to have? Is there a perfect number?
Minimum 3.
I like odd numbers. Odd numbers are useful because then you can't have a tie. A tie goes to the runner, so to speak. You're going to have an odd number, so you can break that tie if that becomes necessary. Once again, I think we're usually going to find our answers in our governing documents. So we're going to scroll down here and say, here's an example of one. It may, that's discretionary, consist of up to 5 representatives, provided, however, that such number may be increased or decreased by resolution of the board. The ARC initially is staffed by 3 persons appointed by the declarant. So during the declarant control period, you got a 3-member ARC. Once the declarant leaves, it may consist of up to 5 members. Normally, so 3 is up to, but not more than 5. Provided it says, however, the number may be increased or decreased by resolution. So if the board is going to only have 3, then the safest way to do it, to dot your I's and cross your T's, to eliminate any question, is to, at a board meeting, make a motion that we have a board ARC that consists of 3 members. And you might say, well, that's kind of silly. Is it really necessary? Well, in light of that last lawsuit, I tell you, it's absolutely worth it to dot your I's and cross your T's. And if you're going to, so look in your CCNR, does it say a number? If it says a number and gives no latitude, have that number. If it gives latitude, then sure, you can have 3, but follow your documents and make sure that whatever you do is in the minutes of the meeting, of a board meeting, so that you can support that if we're ever challenged. Here's one, another set of CCNRs that says, they called it a DRC instead of an ARC, shall consist of at least 3, but not more than 7. So that gives you a range. Served and removed at the discretion of the board, that members need not be owners or representatives. Here's another example of one that need not. So again, the number at a minimum, please don't have one guy doing it, one person, please. And here's what NRS 82 says. Nonprofit laws say each committee must have at least 1 director. So whether that director is a voting member or just a liaison or the eyes and ears of the board, every committee should have at least 1 board member on that committee. And again, like I said, they don't have to always be voting members. They can just be a liaison between the board. But make sure, and again, this won't result in a lawsuit, but just make sure that you have 1 board member who is working with each committee. And that way we satisfy the nonprofit corporation statutes.
John, I have a question.
Please go ahead.
If you're, in your opinion, should just the board members be on the ARC, or does it make any difference? Should we have other folks on the ARC besides just the board? Seems to me you're kind of double jeopardy as the board. If you're,
Yeah,
If
we're
you-
we're gonna get to that very
okay,
good question
then.
in just a second. And it's an important question. And it's gonna depend, the answer is gonna depend largely on the scope of the jurisdiction given to the ARC. And what does our document say? But mostly the concern that we have is there are associations where the CCNRs, and you'll see this later on a slide, where the Architecture Review Committee is given exclusive control of architectural issues. Now think about that. The board appoints them, but their appointees, have exclusive control and jurisdiction over the ARC. They make the rules, they make the decisions, and the board does not have the authority to reverse their decisions. So Patrick, hold that question, because it's going to become extremely relevant when we get to that subject, and we'll talk to you about that in that context of that, if you don't mind. So where do we get authority to have these ARCs? Well, the first one is right back in the nonprofit statutes. The board may designate one or more committees. We talked about that earlier. It's still applicable now. So the board has the authority given it to it by law. NRS 116 has several provisions that are kind of generic, but you can exercise all powers conferred by the declaration. Well, the declaration says there's an ARC. You can exercise all powers that may exercise in this state by legal entities of the same type. Well, we just saw that corporations are allowed to have committees. So the law supports the appointment or creation of committees. And quite frankly, for you board members who are working so diligently in your association, having committees are good. It helps delegate some responsibilities from you, gets more people involved, and gets them educated as to what goes on in an association. Here's an example in a CC&R. The board shall appoint a design review committee. Shall is mandatory, it's not a suggestion. So the ARC authority to act, delegated power, the board shall appoint a design review committee to assume jurisdiction over matters within the scope of the delegated authority of this chapter. So there's an example that says, so the CCNRs talk about it. And here's kind of what I was alluding to earlier, Patrick. Is the ARC subject to the board, its decisions, or is it a separate entity with exclusive jurisdiction over the ARC issues? Keep in mind that an ARC is not a separate corporate entity with the filing of the articles of incorporation, the separate entity. The ARC is just a committee created, if you will, under the umbrella of the board. And so take a look at some of these provisions. Responsibility for administration of the design guidelines and review of all applications shall be handled by the DRC, subject to the right of the board of directors to exercise such DRC rights as it determines. So in other words, this seems to suggest that either the board can serve as the DRC, ARC if you will, or at a minimum that the DRC or ARC's decisions are subject to the right of the board to supervise. Let me give you an example. I was working with an association years ago where there was a height restriction in the backyard. It was adjacent to a golf course. The height restriction in the backyard was 5 feet. A gentleman purchased a 7-foot high water feature. And so the feature, even when it was, in fact, the base was buried, it was still 7 feet above ground. So it was in violation of the governing documents and posed or presented an impediment, if you will, for some people because of the height of this rather large water feature. Well, the person never asked for approval, but built it, and we had to send a letter asking him to please remove it and whatnot. Well, the board had appointed some new members of the ARC, and so the guy decided, well, I'll go ahead and submit my ARC application now, the ask for forgiveness approach. And 2 of the ARC members were new, and so they approved the ARC. They didn't realize, well, Either they didn't understand at the time about the 5-foot height restriction, or they just missed it, but they approved it. And this was a Thursday. The following Monday, a board member saw that, who was aware of the dispute, they were enforcing the CCR, and he about choked to death. He said, oh my gosh, we just approved this thing. What do we do? So we immediately, on Tuesday, sent a letter to the homeowner retracting the erroneously given ARC approval. And let me explain the rationale, because since the person did not incur any expense after he received the approval, in other words, he didn't get the approval, then go out and buy the item, he had already put it in, he couldn't say that he had detrimentally relied upon the approval and incurred this big expense that the board might now be responsible for. We did go to court. The judge ruled in favor of the association, requiring the item to be removed. He got so mad that all he did is behead. It was in the form of like a woman, and he went out and cut off the head so that it was now below the 5 feet. I was dumbfounded. I couldn't believe it. But the association won, and in that instance, even though the ARC was had the jurisdiction, the board had the enforcement obligation with respect to the governing documents, and so it worked hand in hand. But this next one isn't quite as good. And again, this is verbatim from a set of CC&Rs. All questions of interpretation or construction of any terms or conditions in this article, which is the article governing ARC, shall be resolved by the ACC, and its decision shall be final, binding, and conclusive on all of the parties affected. So Patrick, let's go back to your question. Can the board perform the function? I think the answer is yes. And here's an example of one where if you could find ARC committee members who are like-minded or understood what the board's concerns would be, fine. But here's an example where the ACC has exclusive jurisdiction over that issue. Its decision is final. The board doesn't have the right to go in and, if you will, reverse course based upon the exact language of the CC&Rs. So this is a little bit scary.
Yep.
And that would
John?
be, yeah, so go ahead, Lance, sorry.
Just for our clarification, ACC refers to who?
Architectural Review Committee. This is the Architectural something committee, but it was the same as our ARC or whatever. So in this case, the board had the authority to appoint people to that what they called the ACC. But once the ACC made a decision, the board couldn't fix it. The board couldn't go back. I mean, this would only be a problem if the committee approved something that was a violation. Obviously, they denied it. That wouldn't have been a problem, but that it meant to be the ARC in that situation. It's just that association defined it as an ACC instead of an ARC. So I hope that's helpful. Okay, so again, our governing documents, and here's another one. In this case, the association defined the term reviewer. And so during the developer control period, the reviewer was the declarant. And then after the declarant time period lapsed, the reviewer became either the board or the Architectural Review Committee. Okay, so if we had an ARC and that ARC was created, look and then plug in the word ARC where it says reviewer, the ARC shall have the sole discretion to make final, conclusive, and binding determinations on matters of a study judgment and such determinations that are not subject to this other section for judicial review. So once again, this set of CC&Rs appears to grant to the committee the authority to make decisions that are final and binding, and in some sense usurps the board's authority. And ironically, think about it: if a lawsuit ensues, the board's going to be the one that's having to enforce or defend. Rarely is the ARC a part of that, because keep in mind, they're not a separate entity. They're just an appendage to the association and the board's delegation of powers. So this is just an example of something that might be, and so you want to take a look at your CCNRs and make sure we don't run and have something like that in there. If so, we want to try to amend it. Does the ARC have the authority to adopt architectural guidelines or rules and regulations for architectural projects, or does the board, do they have to get board approval for the architectural guidelines, or does the ARC have the authority to do it on its own? Do any of you have any knowledge of what your documents might say on that subject?
Our docs say that the board has to approve it and then that's go to the homeowners.
Excellent. That's the way, is that Ray? That's the way we sure
Yeah.
prefer it to read, because look, we want the committee members to participate, to help out, to help create. They maybe even identify the issues of concern. But man, we sure don't, it's called, I don't like the tail wagging the dog. The board is the one that's ultimately responsible and has liability, and then we got the committee that makes the rules, then they enforce it, and all of a sudden we have the conflict. So what you described, Ray, is the preferred methodology. In this one, this CCNR says declarant shall prepare the initial design and development guidelines, and it made me think back to Patrick's comment that I wonder if when the developer was in control, if they just bypassed that, they don't have this provision, they didn't create detailed guidelines. Instead, Patrick inherited a situation where they had to come up with, maybe create their own. So again, during the developer period, it looks like the declarant prepares the initial guidelines, but then you drop down, it says the DRC shall adopt the design guidelines at its initial organizational meeting. Well, so that puts a lot of burden on the DRC if they're going to start creating these guidelines right at their first organizational meeting, which usually means after the transition from the developer control. But this is an example of a set of CCNRs that say it's not the board, but it's the DRC that does it. And this again says the committee shall adopt rules and development standards. And so this goes back again to the question, wow, who do we put on that ARC if we understand what control they have over the process? So what's your understanding if the ARC guidelines, the very specific things, so let's say we've got this general set of CCNRs, and then we have a very specific set of architectural guidelines. If there's an inconsistency or conflict, what would control? Any thoughts?
I would imagine it would be the CCNRs, right?
You would imagine absolutely correctly on that. Hierarchy kind of goes like this. First, 116 says, if we're going to adopt rules, and architectural guidelines and standards are on the same level as association rules. So if the association adopts architectural guidelines, they must be consistent with the governing documents of the association. If you were to adopt a rule or guideline that's inconsistent with the CCNR, it's not enforceable. Here's a CCNR example that says if the conflicts between the declaration and any of the other governing documents, articles, bylaws, the declaration is what prevails. So in our association, in our associations, excuse me, it is the CCNR that is what you would call supreme. It's what is, if there's a conflict, we always default back to the CCNR. And then here's another one that gets kind of said, there should be no limitation on the scope of amendments to the design guidelines so long as they don't conflict with or modify provisions of the charter. And in this association, the CCNR was called a charter. So that's basically the CCNR. So again, you can adopt these guidelines, but they cannot conflict with the CCNRs. And this goes back to your question, spot on, Patrick. May the board perform the ARC function? Is this a recommended practice? First, the recommended practice is to get as many people involved in the association as possible. So having committees is a good thing in general, or in a vacuum. When might it be the best practice to have the board perform the ARC function? In some of those scenarios we just talked about that Patrick brought to light. When there is an ARC that has exclusive control over the decisions, that's a scenario where the board might say, well, wait a minute, we're going to go ahead and do that so that we don't have this conflict down the road on a ARC application that might have been approved inconsistent with our documents. So that's one time. But again, as a general rule, I do encourage my clients to get as many people involved in the association as possible. When you're in these uncompensated positions and you've got families and work or retirement or something else in your life, trying to divide the responsibility among more people is a good practice, but it may not be one you can utilize if the CCNRs give way too much control to the ACC. And I can assure you that we had out in Pahrump, I was working with an association there, and the ACC had kind of gone rogue. They had a couple of guys on it that they understood they had exclusive jurisdiction, and man, it got pretty ugly. And so the board had to remove them from the ACC or ARC because of that. But that just creates ugliness and hostility and uncertainty. So here's an example of one. The board may constitute and later dissolve a DRC, provided that if there is no DRC, the board shall perform the functions of the DRC. So this document actually even contemplates that the board might perform that function, and then giving the board the authority to approve the guidelines as recommended by the committee. That is a great way to do things. So you let the committee do the groundwork and bring the proposals to the board, and then let the board exercise its authority to adopt the actual design guidelines. And then they give them back to the ARC to enforce or to make decisions based upon.
Hey, John, this is Paul.
Yes, Paul.
We have a very new community, and right now my feeling is that we have 3 members on the board, and we're doing the ARC decisions. And I think right now, for a new community, it's nice to have the board doing those decisions till we have some sort of consistent pattern and understandings, because we're talking about making some modifications to the ARC rules, and I think it's nice to have the board just doing it right now. So that's our rationale.
Well, I think that's a great rationale. Think about it. One of the things that happens is precedent gets created based upon sometimes those early decisions. And so by having the board perform that function, you prevent perhaps some precedents that you're going to have to reverse in the future, but that's really hard to do. So I really appreciate you sharing that, Paul. I think that's a very astute observation, a good time for the board to do that function. At least to maybe get a patterns and practices or even some guidelines that you feel are clear and clean, and give the ARC the ability to go forward, seeing what you've already done. It's a great comment. Thank you. So if the board performs the ARC function, do the laws governing board meetings apply to the ARC meeting? And please note, there's a typo. There should be a 3 after that 8. So it should be 116.31083, which is the board meeting. 3108 are the membership meetings. So I apologize for the typo in there. But if the board performs the function, have we now converted that meeting, the ARC meeting, into a board meeting? And so look at all the requirements: notice of the meeting, agenda, minutes, quorum, member forum for members to attend and participate in, open to the membership. Any thoughts on that? Do we have a problem now? That have we created this issue because the board is performing the ARC functions?
For our community, this is Paul again. We have a specific program that we go to when we're making these decisions, and so it's not part of the board meetings. It's separate. We share our thoughts and feelings within this computer program or website, and that's how we make our ARC decisions, not in the board meetings.
Excellent. Let's take a look at reason why Paul is spot on here. first, I put up this statute in 116 so you can kind of see the general rule. The general rule is upon written request, we have to make all the books, records, and papers of the association available for review. And keep in mind that that ARC applications are association records, right? So 116 says, upon the written request of an owner, the association has to make the books, records, and papers available. That's the general rule. But then there's an exception to that rule, which says the records, it says that the provision, the general rule does not apply to records of the association relating to another unit's owner, including architectural plans and specifications submitted by the owner. So while there's this general rule of access to records, there's an exception for this. Now you'll say, but wait a minute, John, I thought you were talking about board meetings, not access to records. Well, 116, the Nevada Administrative Code also says you cannot disclose confidential information relating to a unit's owner unless the disclosure is consented to by the person to whom the information relates. That architectural application is that person's records. It's in his file in the HOA records. And under 116, since we don't have to produce it, it's this exception to the rule, those architectural plans and specs are deemed confidential unless the disclosure is consented to by the person to whom the information relates, the applicant. So maybe this is just a rhetorical question, and if it is, I apologize, but how can the ARC meeting be open to the membership? How can it be a board meeting if the architectural application being reviewed, discussed, and acted upon is confidential? How can homeowners come into that ARC meeting just because the board's doing it and listen to the discussion, the dialogue about their application, unless the homeowner approves it? So I think what Paul suggested is that they've done a very good job of delineating or segregating, if you will, board meetings and ARC meetings. Board meetings are subject to 116, must give notice to homeowners, must allow homeowners to attend, must allow homeowners to speak, must have a quorum of the board, must have minutes and agenda and notice. But committees are not the board, and committees are not subject to 116's requirements. In fact, you will look in vain for a statute in 116 that says that committee meetings are governed by 116. Even though they are committees created by the board and board meetings are governed, there's nothing that says that committee meetings have to be open to the membership. So I think Paul's association is doing it correctly. The board is performing the function. They're doing it in a manner that is confidential. If they have questions, they might talk to the applicant, but their discussion among themselves does not invite conversation of other homeowners. So Paul, I think you're handling it properly, and I think that's what we want to do. But there are some associations out there, and that's why I added this, who have the mistaken belief that, oh, the board's taking the action, so that converts this into a board meeting, and it does not. So the practice that Paul described is something you can all emulate if you'd like, because I think it is appropriate. So. Is the ARC required to act on an ARC application within a set time frame? And if so, what happens if we don't meet that time frame? Any ideas?
Again, oh, go ahead, Patrick.
No, go ahead. That's right.
Oh, I know with ours, we do have a time frame. My personal opinion, and we haven't really discussed it much within our committee, is that, if we don't get our stuff together and get these things decided, I think, it's inappropriate to make the homeowners suffer by not giving an answer and then just having it be an automatic no. I think, I think board members have a responsibility and the art committee has a responsibility.
Thank you, Paul. I think that fiduciary duty keeps coming in and requires reasonableness on the part of an association. So that's a great point. Patrick, did you want to?
Well, I was going to say our particular situation, what we inherited is the statement that says we have 45 days, but if the 45 days expires and we haven't made a declaration, that technically they're supposed to accept that as being rejected. And I was going to ask you, is that appropriate? Is that going to get us in trouble? I mean, we try to do everything within 45 days, but a lot of times things are going back and forth, and sometimes, particularly in the early days, it got missed. We haven't run into trouble with that, but you're, as Paul just said, you're kind of holding people up from doing anything, and the assumption is, okay, well, we rejected it.
Great point. And at the very beginning of tonight, Lance brought up the situation about incomplete architectural review applications and then some of the problems that we have and maybe getting them to get them. It's always been my belief that the time period begins to run when the application is complete. If they haven't given you what's required, you really can't make a decision. But it is incumbent upon the board, I think, to act within the time period to at least disclose to the homeowner that he has incomplete. So again, I want to show you this. And gentlemen, both of you that commented talked about a situation where if you didn't act in time, it was deemed denied. Well, in the old days, it was almost always deemed approved. So here's a set of CC&Rs that say the ARC, if the ARC fails to approve or to disapprove an application, they gave them 60 days, the application is deemed approved. And look at this next one, within 30 days, or then such approval is not required if you don't get back to them within 30 days. I think, Patrick, 45 days seems to be the norm today, but we see them range from 30 to 60. I randomly grabbed two, both of which 160, 130. If you didn't act in time, deemed approved. And let me walk you through another fact pattern. We had a lawsuit that came up on this. So a homeowner submits the application, it's time stamped, and then management misplaced the application. Folks, let's be honest. We're all human, and there are going to be mistakes that happen in life. And in this particular case, the application was lost and unfortunately was not discovered until the time period in the CC&Rs had lapsed. So in that association, it was deemed approved. Well, the homeowner starts construction. So what does the board do? Is there any relief? Because again, this says it's deemed approved. Tough case, huh? You don't want to be the board in that situation, or the association if there's a lawsuit. But the board caught a break. Well, what was deemed approved? Just what was submitted, right? So if I submit an application, time lapses, deemed approved. Doesn't mean I get to unilaterally change it. And this homeowner had accidentally, when he submitted the application, he was putting in a deck with a staircase from the ground floor up to his deck. He had drawn, the submittal had it going up on this one side of the house. He starts putting it in, it's on the wrong side. He was not building consistent with the plans that were deemed approved. So it opened the door, because now that he wasn't building with approved plans, and the association was able to negotiate some things with him, he ultimately got his deck and he obtained what he wanted, but not without making some concessions to the board on color, location, and other things, landscape as a buffer, things like that, because oops, he made a mistake. So if it is deemed approved, what's deemed approved is only what's submitted, and not if they go, well, I'd like to change this now, and they do something different. That is not deemed approved. So the litigation actually settled with an agreement that the guy got, but only after the association was able to extract some conditions that were very helpful. This provision is more in line with what you gentlemen referred to. Prior to commencing any work, they're going to submit boards of directors or any committee appointed to the board shall answer any written request for approval within 90 days. Wow, that's, folks, that's a long time. I suppose if it's, I think you were talking about that brand new construction. Sandy, I think it was Sandy said that in their new, they had, their new community. And so, maybe they're, if they're actually looking at housing where you actually have to approve homes or whatnot, maybe 90 days. But, and in this case, like in your case, failure to answer constitutes denial. So can you understand the frustration of a family who wants to make some improvements? So put yourself perhaps in this position. You've submitted an application. You wait 90 days.
Yeah, to see what I'm saying.
Excuse me? Okay, so anyway, so you wait the 90 days, 3 months. Time lapses, deemed denied. You don't get that item you've been waiting for, and now you're back to the drawing board. Is this an enforceable provision? Yes, but I still think that there is an overriding obligation of the board to fulfill a fiduciary duty, which means they act on an informed basis, in good faith, in the honest belief that their actions are in the best interest of the association. And so my hope is that our ARCs are meeting frequently enough to address these issues. And if it is incomplete, so the board doesn't feel that it can make a decision, that there is something in writing back to the owner explaining it's incomplete, asking for what's needed, and clarifying that the 90 days or the 45 days or whatever will not begin until they submit the plan. In other words, in essence, you're denying the plan because it's incomplete, but inviting them to resubmit so that you can then make an informed decision on the whole thing. And this last one has no time period, guys. How fun that one, huh? This one just says, provide the committee's approval or disapproval of such plans and other materials shall be given in writing within a reasonable time. Reasonable. We get to argue what that means, but I think that in a judgment, if I was in court and I had to, with the court, I would just introduce evidence that the standard in the industry is somewhere between 30 and 60 days. And if they went beyond that, then maybe it wasn't reasonable. But if it was within 30 to 60 days, it probably was. But once again, this just causes us to make sure that we are doing things in a timely manner and understanding there are consequences if we don't. And so that's kind of what, I'm sorry, go ahead.
John, so this is Paul again. So maybe we should have in our ARC rules something that says, that the timeline starts when the application is complete, like you mentioned earlier.
Absolutely. And if we, in our ARC guidelines, we tell them, hey, we need 3 copies or whatever of your ARC application. We need the photographs, we need the drawings. If they need to be prepared by an architect or a professional, this is what we need to be able to make the decision. And we don't just need, we need to know locations where you're putting things. We need the drawing and whatnot. And absolutely, then I think, Paul, if you can then put in the next thing is we need to respond within this period of time, but that implies that we've received a completed ARC application. If it's not complete, we will notify you, and the time period will begin once you've resubmitted the complete application. I think that's an appropriate provision for a set of ARC guidelines. So again, if there's no time limit, then I think it's reasonableness. And I kind of shared with you, I'd say between 30 to 60 days, because that seems to be standard in the industry. If the time frame is missed, then there are consequences. Sometimes they're bad for the association. If something's been missed and it deemed admitted or approved. And then this raises the question, could something as simple as missing a deadline create a precedent for future applications? Go back to that fact pattern where the guy wanted to put a patio in his backyard. And he's gonna have a staircase from the ground level of his backyard up to this. But the location was such that the person had a pretty good shot into neighbors' backyards, privacy issues, things that might arise. By missing the timeline and creating it where this has been deemed approved, does that mean that the next guy who asks for a balcony that we might think kind of is offensive in the sense that it violates some privacy issues, are we stuck with that? Have we created a precedent simply because, oops, we let a time frame lapse? I would argue, no, we have not. Accidents happen. And just because once we missed it doesn't mean it becomes precedent for everything. But you can see that the next guy that applies is going to say, well, wait a minute, I'm going to see that guy right down there. You let him do it. Well, actually, we didn't let him do it. The time lapse. But anyway, so we want to avoid those problems that can be. So do what we can to make sure that we act timely. How about that?
Can I say just one more quick thing?
Please,
one of the
please, you
reasons-
guys speak to that.
One of the reasons for the ARC rules are because they do change over the years. Is that someone might say, hey, this person, like our models in our unit have trees right next to the walls, and all of our ARC rules say they have to be 5 feet away. And they say, well, they did it, why can't I? That's because the ARC rules changed as soon as the declarant left. It became 5 feet away. The declarant didn't enforce it. And so those people that have the models have trees right up against the wall, and everybody else has to put them 5 feet away from the wall.
Well, I hate to break, Paul, I hate to break to that guy with the tree right next to his wall. And about 10 years from now, his wall is probably going to start cracking from the tree roots pounding on his wall.
That's true, but the ARC actually protects the homeowner in that, if you get an approval, you're grandfathered in for the rest of your life as long as you don't change what you have done there.
Yep,
And
that's
so
fair.
that's what that's one of the issues I see with our new community is I don't think our homeowners have read the ARC rules, and I wish we had a better communication process that really informed our homeowners of what this process is and how it protects them.
I want to come back to that communication part, but I also wanted to share this with you. Represented an association during the developer control period. The developer put in the wall that ran between the homes, but did not do the return wall to the house. So each homeowner, and they bought their unit, had to put in their return walls, and some would ask for gates, some wanted recreational vehicles behind their gate walls, which they would do nice gates or whatnot. But during the developer control period, the developer actually approved some wooden gates. Well, you don't have to live in Vegas very long to know what happens to the wood in the intense heat that we get. It peels, it warps, it gets all kinds of problems with wood. So when the transition took place and there was now the homeowners, the board adopted a new regulation regarding walls and fences and said, no more wooden fences. You could do the wrought iron or other things, but we can't have wood. Well, a homeowner buys in a home later after this new rule, drives the neighborhood, sees a handful of these wooden gates, submits an architectural application. It's denied. He gets angry, puts it up anyway. You end up in a courtroom and the judge made him take it down. Why? Because the board had drawn a line in the sand and created a new standard. And from the date that they created that standard of no wooden gates, the board had universally denied any application for one and had required others to remove them. So even though, yes, there was this precedent set when the developer was there, a new board, a new ARC, whatever, can create the new standard and send that out and can then follow that going forward. So like you said, the original person that had the wood gate, they were grandfathered in because it was approved. But then once the ARC guideline changed, it applies prospectively to all future applications and it would apply. So I like your example and I think it's very legitimate. By way of communication, I don't know if your association has a newsletter where that maybe once every 3 months or whatever, you'll send out a newsletter to your homeowners. I've recommended that you use the newsletter to highlight issues of concern in your community. And if there are issues of concern, I know that not everyone's going to read the newsletter. I know that, but I would try to do whatever I could to educate them more fully on those maybe lesser read provisions that, Paul, might be leading to some confusion or frustration with your homeowners. You know, we can't make them read them, but I guess we can try to bring it up as many times as possible. So just a thought. It may not work, but maybe it will a little bit. This next subject is one that has really evolved in time in my 30 plus years of law practice with HOAs. Y'all, do you know the difference between neighbor approval and neighbor awareness? Do any of the associations represented here tonight use either one of these types of items as part of the ARC approval process?
Neighbor approval.
I know we have neighbor awareness, not approval.
Okay.
Ours isn't written in anywhere, but we, as a board member, I always ask if they have asked their neighbors, you know, if it's all right with them.
Good, Nancy. So in your association, there's nothing that you're aware of that specifically requires it, but you've at least inquired as to, yeah.
Right.
Okay.
Ask them if you've asked their neighbors.
Yeah. Have you checked with your neighbors?
Right.
What they,
So the first question, does the law, is there a statute somewhere that requires neighbor approval? And the answer would be no, you won't find that. Do the association's governing documents require neighbor approval? So does the CC&R specifically say, as part of the approval process, you must get the consent or approval of the neighbor to your plans? Most that I've seen over the years don't require that. In fact, the neighbor approval or neighbor awareness requirement is a creation of the industry. And when I first moved here in the late 80s and was working in HOAs, we would, yeah, we want your neighbors to know what's going on and to sign off. Well, there's a problem with that. And then let's go down to the next one, neighbor awareness, which is a little bit different. It's more in line with what Nancy was saying. The neighbor doesn't have to approve it. Yeah, I think this is a great thing, I approve it, but is the neighbor aware of what is about to transpire next door? There's going to be some construction, there could be construction trucks, there could be some things going on. Are they at least aware of it? And once again, you'll find that there's nothing in the law or in most governing documents that discuss the neighbor approval or the neighbor awareness. In both instances, it is a creation of our design guidelines or our own rules. In other words, we are asking that to be part of it. And this is one of the areas where, you know, I love Fiddler on the Roof, great show. And remember, tradition. Why do we do this? Well, it's tradition. And that's why we do it. And I think what's happened in our industry is that over the last 35 years, it's how we do it. We require them to, well, why? Because that's why we do it. Well, why do you do it? I don't know, but it worked 35 years ago. It must work now. And so what we're kind of stuck in this is that we're requiring something because, and we can make good arguments for it, but I want to show you where some of the problems lie in this process. Where are we at here? So obviously the difference between neighbor approval and neighbor awareness is one actually requires the neighbor to review and approve it. And the other is just the neighbors put on notice. They're made aware of what's going on. There are very different standards. And what are the problems or approval with neighbor approval? Are we giving the neighbor a veto power over the project? If you require neighbor approval and the neighbor doesn't like the idea of that little gazebo on their side of the backyard and they refuse to sign it, aren't we basically saying that we're giving the homeowner the ability to decide? And oh, the guy around the corner, his neighbor didn't care, so he has the exact same gazebo in the exact same location, but that neighbor approved it, and my neighbor, he doesn't like me that much, so he won't approve it. Do you see the potential problems in giving the right to approve to that person, that neighbor? So what if we're gonna just require neighbor awareness? We're not gonna make the neighbor approve it, but we want the homeowner to at least let them know. Well, what if they're absent? Well, what if it's a vacant lot? What if, or you're vacant, what if the person's a snowbird, only here a few months of the year? What if they just are the kind of, I'm COVID, I don't want to talk to anybody anymore. I'm in my house. I don't want to sign anything. Please don't come over here or whatever. How does the person, the applicant, satisfy the neighbor awareness? Or do we have exceptions to neighbor awareness when the applicant says, I've tried, I can't get him to open the door, I can't get him to talk to me, or they won't sign the thing saying I talked to him about it? Those of you that have this, have you ever been confronted with that type of scenario, and how have you handled that, or would you be willing to share that?
We, in our community, we did, I was actually looking up some past documentation because we had a homeowner back in September and they had a wall between the two properties, and the one homeowner wanted to make a wall modification and move the wall forward to enclose more of their side yard. So we did our board had them fill out a neighborhood awareness sign-off form to get each side and their rear neighbor to sign off on it, because our concern was if they wanted to modify the wall, there's one wall going down the center of their yards, and then they each have a forward part of the wall. So if one neighbor wants to modify the wall, how would it affect the other neighbor? I mean, you can't, obviously, without awareness and willingness, allow somebody to modify the wall, because it's going to affect both homeowners. But in our case, we did get the awareness form signed off by all parties.
What's interesting in that fact pattern, Debbie, is that if you are going to modify a structural component that is straddling a property line, so if it is a walk wall that's kind of part on each side, that is the one scenario where getting the neighbor approval or consent to, like if they're going to heighten the wall or extend the wall and it's going to be on that property line, then to get a permit, you would need the owner of both sides of that wall to agree. So that's the one time. So that's a good example, though, of where you got them to work together to do that. Again, I'm just sharing. This is one area that I'm not here to sell you a bill of goods, but I will tell you that, like I said at the beginning, my opinion has evolved a lot over the last many years. I used to be in the, oh yeah, my documents say approval. And then I got to the point where, no, we can't do that. That's a veto power. No, we're going to require neighbor awareness. And the last 3 years, and again, folks, forgive me if I sound like I'm up on a pedestal or on something, but man, COVID has just not brought out the best in everybody. And I'm not even sure I want my neighbors some people going next door and talking to their neighbors, because there's so much animosity and whatnot that I'm not sure that they could even get their neighbors to talk to them civilly or even talk about it. So I've even come up with an idea, and I'm just throwing this out there. I'm not saying this is right or wrong. So I'm just trying to brainstorm with you, but what if the board, as part of their process, after the application is approved or conditionally approved, what if they require the applicant to just notify their homeowner in writing, the neighbor, hey, just to let you know that we have an ARC that's been approved and we're gonna have some construction between August the 15th and we hope to be done by September the 2nd. And we just want you to know so that when you see cars or trucks or dirt or rock or whatever delivered, you don't, get too excited. We just want you to be aware, or the board could send something like that. So I'm not sure that there's an absolute, but I just want to make sure this is purely a creation of us. This process of neighbor awareness is purely created by the industry. Management, attorneys, all of us have been doing this for a long time. This has been part of our makeup is, we got to have the neighbor awareness. And I guess more than anything else, I hope we will, at least this dialogue will have us think, do I need the neighbor awareness, or could it be modified slightly? Or do we have exceptions to the rule where the applicant can verify that, I've really tried, but it's just not working? And so those are just some thoughts I hope that you'll think about as you meet with your board to consider this going forward. Okay.
We have a little bit of a different situation, the way that it's done with our association. We neither have awareness or approval. What we have is what we call a neighbor impact form. And what we use that for is if something's going to be located close enough to the property line or on the property line that's going to impact a neighbor, we do that as kind of a beginning arbitration. If notice of some type, and we've actually used that where we had a neighbor who wanted to do something with a driveway and the neighbor next door wasn't in favor of it, and we actually forced them to get the NIF, the neighbor impact form. And there was some discussion, and the agreement was that the neighbor that wanted to do it could do it, but he had to have agreement with the neighbor next door that he was okay with it, or else there was an alternative that was going to be used, and it actually worked out pretty good. So don't know if that helps anybody or not.
Yeah, I appreciate that. I would probably treat that akin to a neighbor awareness, because you've identified impacted neighbors, and we're just letting them be aware because of that impact. And I don't think that's a bad standard. It's we're just trying to let the people know, because it's one of those things where, that's why I said this is my castle, I ought to be able to do whatever I want. Well, when you have neighbors, and if the conduct at your place interferes with their quiet use and enjoyment of their property, somewhere you've got to at least try to get along and try to work together in these communities. And that's why common interest communities can be such a challenge, is you got to check some of your preferences at the door, so to speak, because you are living with people who don't always share your same taste or beliefs. So what are the standards that are used to decide whether an application is going to be approved or not? Where do you find the standards? How do you decide? Well, that's just flat out ugly. Okay, well, I think that's beautiful. Well, I don't. I think that's ugly, and I think that. So how do we decide what we're going to approve and what we're not going to approve? Are there standards somewhere? Do we just go with the flow? Do we how do we kind of deal with this? Someone has submitted a request and we're going to say yes or no. What do we look for the standards?
I know in our ARC rules, there's a lot of, must match, this, that, and the other. I'm one of these people, I like to see some individuality, but we just need to, and that's what we need to do, is tweak our ARC rules a little bit more, so we have a clearer view of this answer to this question.
Well, let me tell you an experience I had, and thank you, Paul, for sharing that. First off, if there are any specific standards, they would be in your CC&R. So if there's a specific CC&R provision that says, hey, guys, these are the standards that we use in deciding it, and you need to use those, then that's where this all begins. So I'm going to first show you a set of CCNRs. And it said this. So this is the first paragraph said the ARC shall review and approve or disapprove all plans submitted to it based solely on the considerations in this other section. Oh, okay. So then I went to that other section. Well, where's my, there we are. And this is what it said. Will the construction, alterations, or additions contemplated be detrimental to the appearance of the surrounding area as a whole? So again, number 2, will the appearance affect the harmony in the surrounding structures? Will the construction will not detract from the beauty, wholesomeness, and attractiveness of the property? And again, these are pretty broad terms, because what one person thinks is attractive, another one may not like. So, and I can tell you that right where I live, I mean, there's homes that I think look beautiful and homes I think, oh my word, the guy must have bumped his head when he was doing the drawings. Those are ugly, but that's just me. He may look at my house and say, man, that dude needs to find a better architect. So the last one says the upkeep and maintenance will not become a burden on the association. So whatever you're doing, it's not going to make the association pay. So this was right in the CCNR, right? Well, remember that association I told you where they only had the one guy on the board and they were getting their bottom handed to them in court? They had to create their own set of architectural guidelines, and this is what they did. For purposes of determining whether a plan can be approved, they're going to look at the following factors, and you'll notice the first 4 are the same 4 that we pulled from that other set of CCNRs, because this association had the same builder and they had just plagiarized their own document. So you'll see the first one is, it's not detrimental in appearance. The next one is it's harmony. It doesn't detract from beauty and wholesomeness. The last one or 4 is it doesn't create any burden on the association, but we added a 5th one. And this was right in that association CCNR. Will the proposed construction, alterations, or additions unreasonably obstruct the view from any lot? Now, that was right in the CCNR. I did not create this, but we did try to pull together into one document the standards that the CCNR said. It also educated the ARC to know the standards that they were supposed to do, not create your own. This is what the CCNR said. This is what was dropped into the board resolution. And as some of you have talked about your architectural guidelines, this is what was dropped into their guidelines as to how they were going to make a determination on something, to try to make it as specific as they could. At least to let them know what they were going to rely upon when they were trying to make those decisions. So if you don't have these, if you don't have any specific things, then look around and try to create your own design guidelines. These are good types of provisions to copy from if you feel that it's useful for your association, but create at least some standards that will make it easier for your homeowners to see consistency and transparency in the association. Oops, there we go. What options are available to the ARC? Can the ARC approve an ARC application with conditions? What are the options that you got an application? What are the options that the board has? Well, you can deny, right?
I know with ours, we can approve with conditions, or we can ask for more information.
Excellent.
Or straight out deny.
So you could deny, or you could ask for more information, approve as is, or approve with conditions. Okay, that's very good. That kind of sums up what I think are the options that you have. Here's an example that just said, the reviewer shall make a determination on each application, and down below it says the reviewer may approve the application with or without conditions, approve a portion of the application and disapprove other portions, or disapprove the application in whole. This one didn't give the option to ask for more information, but I do believe that that is inherent in your ability to approve and disapprove, is to ask for more information. So I do like that as a criteria, but if you get an application and they want to put in a pool and a pool house and some landscaping and whatever, it's okay to approve some, but not all of it, but you just need to make clear in the response what you are approving and what you're not approving. And I'm also going to say that it's become my experience that you're almost never going to just say, we approve. And I'm going to show you because there are some conditions that become problematic. The Architecture Committee shall not be responsible for reviewing, nor shall its approval or plan or design approval shall be a deemed approval of the structural safety or conformance with building or other codes. Look, I don't know about you, and I may have some architects and engineers and contractors on this Zoom thing tonight. I'm not one. And I'm not a good judge of structural safety or conformance with building codes. I mean, I think that's why we kind of hire a contractor, because they know if we need permits and whatnot. But you should condition any approval on the compliance with any municipal or building codes. In other words, you don't deny it or say, well, we can't approve it till you get their permission, but you can approve it on the condition that they meet and satisfy the building or municipal code for that construction, whatever that might be. You can even tell them, we need you to submit a copy of your building permit that you get from the municipality. We need a copy of the inspection at the end that has been approved by that entity. You can all make all of those things conditions, but I wouldn't deny it or wait to give the approval until they have someone that goes in and opines on the structural safety. I think you just need to make that a condition so that they know if they don't meet it, then you've got an enforcement remedy. Any thoughts on that, or any comments by anyone that on that issue of building codes and municipal standards?
This is Paul again. I've kind of learned as we've gone along here that I write everything with approved with conditions, because our ARC rules have that kind of stuff about pulling permits and all that kind of stuff. And so when I say approved with conditions, it's always referring to our ARC rules. I don't know if that's appropriate, but that's what I've been doing.
I think it's absolutely appropriate. Keeping in mind that the architectural guidelines are part of the process, the homeowner is aware of them, that they have to submit part of that. If it might be good to just specifically say, maybe you're doing this, that this approval is conditioned on your compliance with section 5 of the design guidelines that set forth like the things you're talking. Maybe there's a long laundry list and we put that in there. I've seen some just actually lift those conditions or those things and put them right in the approval. We approve this on the condition that, and they list all of the things that are in the design guidelines. Either one I think is effective, but that's just an example of one. Here's another one. That the construction will be prosecuted diligently and completed within, in this case, not to exceed 12 months. Well, this was a big house. This is a big piece of construction. I mean, you might, someone's putting in a pool, you might give them 3 months and then they can always come back and ask for an extension. But I think part of the thing we want to do here is we want to get the time to approved, and we want it done so that there's not as much inconvenience. Had a funny case where a person came in and asked for ARC approval, and it was approved about 2 months before COVID hit. Then COVID hit, and as some of you may know, construction kind of went on the blink. It was hard to find contractors. And so the person, finding that it became very expensive and whatnot, and couldn't get a contractor, just didn't do anything. Well, 2 years after the fact, they came forward and were going to start approving a construction, and one of the board members said, but wait a minute, it's been 2 years. That's not fair. And I looked back, and unfortunately, there was no condition approval about the time. They gave approval to do this and didn't say it needed to be done by a certain period of time. And so I think they were a little bit stuck because of that. So going back to the comment I think Paul made about the conditions, I think it's very important that you look for and create what are the universal conditions that are important to you in your neighborhood, and then include those in your ARC guidelines or include them in the approval so that these conditions are included. Okay, let's see. Okay, are views protected? Do any of you live in an association where you believe that views are protected?
We have some views in our neighborhood and we don't believe views are protected.
Good. And it's view of what? I used to have that. Well, what's your view? I have this association where there's a fight going on between homes that are not in the association because our HOA is a little bit lower, and so they're higher. They don't like the fact that the association has landscaping and whatnot, palm trees and things that are a little taller. They're saying, well, it's blocking our view. I said, what view? You mean the view of the downtown from way out, or the view of the mountains behind, or the view of a lake? And so obviously, view of what? What is it to be protected view? And so I wanted to share with you, here's a set of CC&Rs that says, the committee shall consider the impact of the proposed height of any improvement. Now, this is talking about the construction, the structure. If you look up above, new building or structure. So the committee will consider the impact of the proposed height of any improvements upon the view from any other lot, and shall have the right to disapprove plans and specs by reason of such impact. Then it goes on to say, no landscape shall be planned or permitted that would block another lot's view. So you're welcome to say, well, gee, John, view of what? Well, the name of this association is Lake Blank View Estates. It's a view of the lake. They're supposed to have a view of the lake. So it's in the very name of the HOA. And so what does this mean? It means that if there's construction up, and again, it's terraced construction, so the upper and then it starts to go down, that the committee shall consider. It doesn't say that it's going to necessarily deny everything, but it's supposed to consider the impact of the proposed height of any improvement, the construction, on their plans. But then again, it goes into landscaping, says, and it just says no landscaping will block it. And then here again, I love this language, and this might be in some of yours. Neither the founder, that's the declarant, nor the association guarantee or represent any view over and across any portion of the community will be preserved without impairment. And so they're making it very clear. So unless your documents expressly say that there's a view that is protected, then unfortunately for you, your view isn't protected. And there are some associations where homeowners may have even paid, in fact, this one I was telling you about, well, we paid a premium for this lot, so we would have a view. And I'd say, well, but the CC&Rs don't say that. I'm not denying that maybe the developer had you pay a little bit more for your lot. Okay. But where does it say that the association has to protect your view? And there is nothing. So again, unless your CC&Rs specifically say that there's a view that's to be protected or be considered, then there isn't one. So just so we're clear on that. What about variances? Does the ARC have the authority to grant a variance? Have any of you sampled your CC&Rs enough to know what they might say on that subject?
Maybe you can't have a diversified portfolio. You're joking, right? No. We buy some refill packages from Chase Auto. We collect all the deficiency balance. We run some hard tools. Hell, if that doesn't work, we follow that and collect. Right? It's all legit. You know, we're good. Right.
Dave, I don't know if you want, there we go. Sorry, I wasn't sure you wanted us to know about that. Anyway, does the ARC have authority to grant variances? So again, I pulled a couple of things that you might consider. And again, this goes back to Patrick's inquiry about, can the board perform the ARC functions? In this case, the ARC may authorize variances, including restrictions upon height, size, setbacks. And so think about this. I think it was Paul that you said that the original development, they had some landscaping that was right against the wall, and then now we have this setback. So does the ARC in your association have the authority to grant a variance to that setback and allow a homeowner, because of the size, height, setback, floor area, they can make this variance based upon topography, natural obstructions, hardship, etc. Can they do that? And again, this is a little bit dangerous because it doesn't say anything about the board. This says the architectural committee can do that as long as the variance is signed by at least 2 members of the committee. And please also keep in mind that for a variance to be valid, it should be recorded with the county recorder's office. So here's an association where the committee has the authority to do it. This one goes back to that word reviewer, which could be the declarant, could be the board, could be the architectural committee, depends on who is having jurisdiction at now. But after saying that they can grant variances, it says, but it says that the variance must be justified based upon topography, natural obstructions, hardship, or aesthetic or environmental considerations. That's pretty standard language you'll see in some HOA CC&Rs. But look, no variance is effective unless it's in writing, makes sense. Can't be contrary to the CC&Rs or prevent the reviewer from denying a variance in other circumstances. So it puts some conditions on it, but once again, gives the declarant, the board, and or the ARC the authority to grant variances. And then here's another one that gives the architectural committee may authorize variances from compliance with the architectural provisions. Such variances must be evidenced in writing, signed by a majority of the committee, and to be effective must be recorded. So that kind of incorporates it. But once again, it's the committee. In 2 of the 3 that we looked at, it's the committee, not the board, that had the authority to grant the variance, which is going to cause you to then ask, should the board perform the ARC functions when they're given this kind of authority? That's something for you to consider after you've reviewed your docs, and certainly consult with your management company, consult with the attorney that your firm's working with, and they'll help you navigate through some of those types of things. Does an owner have a right to appeal to the board? So you have an architecture review committee, they review it, and they say, no, don't like it, it's not going in. Does the owner applicant have the authority to appeal that denial to the board? So this is a test. How many people remember what my favorite answer to any question is? No one?
It depends.
Thank you. It depends. And that's the right answer. Once again, does an owner have the right to appeal? It depends on what? The CC&Rs. Here's one that says the guidelines. So the CC&Rs give the board the authority to adopt guidelines that may provide for appeal procedures. So if you create an ARC and the ARC doesn't have exclusive jurisdiction, then you can create a program or a guideline that says the application goes to the ARC makes a decision. If you get if you get a denial and you'd like to appeal to the board, you are welcome to do so. You usually require them to do it within a certain period of time, blah, blah, blah. But that's something that can be in your design guidelines as long as it's not inconsistent with the governing with your CC&Rs. For example, here's that exclusive jurisdiction one. Remember, the decisions of the ARC are final, binding, and conclusive. If that's what your CC&R says, I don't think you can have an appeal process because your document is given that decision just to that committee. So got to be a little cautious when you get to that. Let's see where are we at here. Is the board required to give owners access to other owners' architectural application? And that's probably too obvious. I'm sorry, guys, but I was probably getting tired, so forgive me. And obviously the answer is no, and we're going to show you why. We kind of talked about this in the context of whether we convert, if the board does the ARC, if they convert that to a board meeting. Once again, here's the provision that says that the general rule of accessibility says the records of an association relating to an owner, including the architectural plan and specification, is not subject to the rule of accessibility. The only way that an owner can get a copy of his neighbor's architectural plans and specifications is from that owner, or if they had to file to get a permit, there might be something at the city or county, they can go down and get a copy of it that way. But if the owner doesn't want to show them, they give it to them, the association certainly can't give it to them. It's, oh, yeah, they're not going to get you, then here, we'll give it to you. And again, this is that Nevada Administrative Code provision that says, unless the disclosure is consented to by the person to whom the information relates. And so we can't just give someone else access to their neighbor's information. So unless the owner submitting the ARC consents to the disclosure or sharing of the content of the ARC application, the board must treat the ARC application as confidential and not share it. And that goes for the ARC too. Sometimes, you know, the board members, because of that fiduciary duty and liability and everything, you guys do a great job of keeping these confidential, but sometimes our committees don't realize they're under the same obligations of confidentiality. So the ARC would need to make sure that they also understand that we're not going to go out and make a mistake and disclose confidential information. That's just not good. So.
Can I ask a real quick kind of dumb question just to
Oh, there's
clarify
no
a bit?
dumb one, no dumb question. It's not, I always had a professor say the only dumb question is the one not asked. So go ahead, fire
Okay.
away, bud.
Well, you know, being a new member to the board and having the declarant being charged for a lot of this, there are some things that aren't just the model homes that have seemed like they've been approved. And I'd like to go back and look at some of those ARC applications. Am I allowed to do that as just a board member? I mean, I'm a homeowner too.
As a board member, you have greater access to things than do homeowners. As a board member, you want to make sure that you're doing things that are consistent. So knowing what has been done in other cases would be relevant. Let me share something with you. And if I have anyone on here who works closely with developers, this is not a criticism of developers in general. It is an example of something that can happen, is that the developer, we had a situation where the CCNR specifically said, no recreational vehicles. Now I understand this was 15, 20 years ago or whatever, but that's the CCNR. It said no recreational vehicles in the community. It didn't say you can have them in the backyard, or you can have them if they're in the garage. It said no recreational vehicles. I didn't write the CCNRs. The declarant's attorney wrote the CCNRs. Well, not only did the ARC approve an RV, the developer poured the slab into the backyard where the RV was going to go. Well, but the CCNR said no RV. And as fate would have it, these two, the lot and the neighbor right next to them, the lots were vacant. They bought the lot. They bought the lot, and then they picked the home they wanted on it, and there was being construction. Well, when the neighbor moved in, lo and behold, there was an RV right out their kitchen window that blocked the sun. I mean, it was a big thing, and the homeowners were frustrated, and understandably so, because when we bought here, it said no RVs, but here they had an RV that was there, and they even had it approved. Well, long story short, the neighbor next door wanted a bigger RV, bought a bigger RV. That one had not been approved, and we were able to get the Nevada Supreme or the district court to rule he had to remove the RV. But it's only because he changed the RV. If he had kept that RV, it had been approved, but he didn't. He sold it and bought a bigger one, and so he ended up moving when he had to do it. So, but you're making a good point, and that is sometimes the developer, at least in this one instance, probably wanting to make sure they sold a home, agreed to do something that was absolutely contrary to what the CCNR said. And again, I don't think that's the norm. Our developers aren't like that, but it does happen on occasion, and ended up in litigation. So understanding what has been approved in the past would be useful to know whether you want to modify that going forward. Remember, we talked about changing our architectural guidelines. You may find that some things that have been approved so far, we don't want in the future. So I do think, Paul, you're going to have greater access to some of those things to understand what had gone on so that you can use that going forward. But you got to, again, if you get access to those items, you know, there is a level of confidentiality. You can't go out and discuss those with anyone else, but I do think you need to know something so you can be consistent going forward. So I want to turn the dialogue briefly, and I know we're running out of time. I know you all got better things to do than listen to me all night, and you've been tortured as it is long enough. So, but remedies. What do we do? What do we do when things don't go right? Or we drive along and whoops, we see that there's construction going on that was never approved. What are some of the remedies that we have? And let me just, what if the owner does not submit and they just ask for forgiveness? What are your remedies? So now it's already up. It's up, whatever it is, it's up. So can you ask it to be removed? Can you fine them because they didn't get our approval? What if they didn't ask for approval, but you would have granted it if they had asked, but they didn't ask? So now they're in violation of the provision that says no construction without approval. And there's just a wide range of possibilities in cases like this. And the first one is you send a cease and desist letter. And you should do that as soon as you see the construction. Please, whatever you do not wait and walk by that house every day and say, wow, look, John Leach is building a second-story room addition. Wow. And then you wait till it's done and then tell him to remove it. Okay. If you don't want it up and it's a violation or he didn't get approval, you send a cease and desist letter. Usually that first comes from the management company. If that doesn't work, I strongly recommend you get your lawyer involved to write a follow-up cease and desist. And the letter is going to have some language like this in it. We've been advised you've begun construction and modifications to the property, including these. We're telling you to cease and desist. And if you don't stop, there's a long paragraph that talks about the enforcement, violations, and possible fines and things of that nature. So that's kind of what would be in your cease and desist letter. But sometimes you just flat out have to go to court and get an injunction. Get the court to order the construction to stop. It's unfortunate if you have to do that because the expense is quite high. To file a complaint for injunctive relief to stop construction, I'm going to tell you, if you can get it done for less than $5,000, you must have ran into some will work for free lawyering or something, because it's almost impossible. You've got to file the complaint. You've got to file the petition or application for temporary restraining order. You've got to get a hearing from the judge. Then you got to go to a hearing and put all this stuff on in evidence to get the judge to order the cessation of the construction. But if you don't do that and you let the person continue to construct, and it just now all of a sudden now they spent all this money on it, and here's the cases out there that they'll rely upon. It's called equitable estoppel. And what it means is the elements are an unreasonable delay in the assertion of an available remedy and intervening reliance or prejudice. So if you have the ability to stop it, hey, stop, you don't, you go to court, you don't do that, you let them complete it, and you have the ability to stop, okay, then you could lose your ability to remedy it. So these are just a couple of cases that said that. And I wanted to show you this one. In the Woodmore case, the doctrine involved not merely an unreasonable delay, but a delay which was prejudicial. A delay is prejudicial if it causes the defendant, the homeowner, economic harm. Okay, well, if it's a $40,000 room addition and you spot it when he's $2,000 into the project and you wait until he spends the next $38,000, now say tear it down, the judges think of that as waste. You've wasted it. And they're not sympathetic to HOA. So look at this case. Now, the statute of limitations in Nevada on the enforcement of a written document is 6 years. So if I'm enforcing a CCR, I have 6 years. But look at what some of these courts have said. The Florida court, association is stopped from enforcing covenant after waiting 1 year for violation to assert the claim. Down here, condo board waited too long to enforce enclosure built over 1 year earlier. So what these courts are saying is, if there's a prejudicial delay, if you had a remedy, stop construction, and you didn't exercise that remedy, you may lose that remedy if you don't act in a timely manner. So more than anything else, if you see there's a violation, yes, you can go through the notice and hearing process and impose fines. Yes, you should demand they cease and desist. If they blow you off, you may have to get an attorney to help, but even if you do, they may not stop. They could maybe care less. Then you might have to go to court to get an injunction. But you don't want to be the victim of delay or apathy or negligence and just not taking action, which then allows it to stay, particularly if it's not something that would ever be approved under any set of circumstances. So the last subject is some associations have these inspection requirements. And I probably won't go through a lot of, but some CCNRs have this very detailed thing about after they submit for approval, they get approval, they have to finish the work, and then the association has a right to inspect. However, it says, however, the committee's right of inspection shall terminate 60 days after the work has been completed and the owner gave written notice. So they're supposed to tell us, hey, we're done. And then you're supposed to go inspect it within 60 days. And if you don't inspect, you do it. If as a result of the inspection, the committee finds an improvement was done without obtaining approval or was not done in substantial compliance, you give them 60 days to remedy it. So it's a very detailed process on what you do in the event that this continues on, and it kind of walks through the process. And I won't belabor this point, just to say, please look through your CCNRs and see how architectural violations of this nature are addressed. If you have that detailed process, we're required to follow it. In fact, courts are not too sympathetic when we run to court and say, hey, Your Honor, they're not following the CCNRs, they didn't get approval. And lo and behold, we didn't follow our own CCNRs before we got there. So be cognizant of these types of provisions about inspections and how the homeowner has to inspect or rectify what we call defects, or not a defect in the quality of construction, but defect in following the process to do that. This one you see as 90 days. And if we don't respond in 90 days, then it gives them 30 days to notify them to correct it. And then they have to correct it within 30 days after that. So it's just a process that's in your governing docs. So most classes I teach, this is everyone's favorite slide because it means you're done. You don't have to listen to this guy anymore if you don't want to. It's a wonderful slide. So let me just ask, does anyone have any questions on this issue? And if so, I'll do my best to answer your question.
Do have kind of a question here.
Good.
Sorry, this is Paul again. So that's why I asked about looking at this, these past records is, kind of what are the solutions to this? Like we have one home that put white rock in their backyard, and our ARC rules say explicitly, no white rock. That was before I was the board member and was part of the ARC committee. And so I'm just kind of wondering, well, do we go back and look at all these ARC requests and figure out who's kind of following the rules and who isn't? I mean, how intense do we do this? And then what are the solutions?
All I got to tell you is that is an absolutely brilliant point, because you don't want to write a letter to the homeowner and say you're in violation of this provision of the CCNRs that says no white rock in the backyard, if that person submitted an ARC application, was approved, and then he went out and bought the white rock in reliance upon the approval and put it in. So that's a good example, Paul, of trying to say, look, I'd like to review this ARC. I got to make sure that maybe they didn't even ask to put in white rock. We don't know. And so that's why looking at that application would give you some guidance on what the next step might be. Great point. So I think that opens the door for you to at least broach the subject with the declarant or the board or whoever to say, I just in keeping with what could be a possible violation, I'd like to at least take a look at the applications to make sure if we have some violations that we can enforce.
Thank you very much.
John, I have a question.
Okay.
So maybe everybody here is the same situation as we are, but we're a sub-association in Summerlin South.
Okay.
So, of course, we require that they get, for ARC applications, they get that approval prior to us granting approval. So have you come across situations where, say, Summerlin South is either more lenient or more strict than the local association?
Yeah, and I don't know whether it's specifically Summerlin South, but the relationship between a master and a sub is oftentimes fraught with challenges, particularly because they have differences of opinion. And in your case, whether the declarant is still there, because Summerlin is still controlled by a developer versus homeowners. And so the first thing is you have to sit the two documents next side by side and say, does one say that it controls over the other? More often than not, the master CCR will say that if there's a conflict between the two, that the master controls. But usually you can be more restrictive, you just can't be more liberal. So if the master has a policy and you want to be more restrictive, usually that's okay with the master. But if the master says you can only do this, and you say, no, we want to let him do more, that's where most of the conflict arises. So the best thing is I like that you guys are working together. You know, you need to have approval from both associations. One association is not enough. You get the approval from the master and you review it. But I don't believe, unless your document specifically, by golly, this is the way it is. I don't think it's a conflict if you're more restrictive. And so if they said yes, but you said no, because you're more restrictive, that shouldn't in every instance be a problem. It would be a problem if they said, no, you can't do it. And you said, yes, you can. Because then what you're doing is you're saying you can do something you can't do in the whole. And again, a lot of people disagree with me, but I've been a huge believer that sub-associations should be given a little more autonomy to do what they want in the sub-association because they live there. And in a master association, people could live miles and miles away from that sub-association. And I like trying to give each neighborhood the ability to develop their own standard for their community, but you still got to look at it and kind of balances what the master CCNRs say as to what the relationship is between the two. Okay. Well, let me just close with this. I want to thank Mary and PAMCO for putting on these programs. I'm grateful they gave me the chance tonight, but I know they have an educational program that's awesome. And I hope you guys will take advantage of these things that CAMCO provides because it's their way of trying to help you do your job more effectively. I've always believed that education is power, and the more we know, the better job we'll do, and we'll make fewer mistakes because that's just who we are. We're human, we're going to make mistakes, but as we get more knowledge and experience, we do better. But I also want to thank each of you for taking time out of your schedule to listen to some lawyer, because you guys are really the key in this. You're the cog that makes this thing work. You guys, I know the compensation is wonderful, but you guys are just doing a great job of trying to give, donating your time and your service to your community. And I don't know that people usually don't appreciate it until they step in your shoes and find out how many things they really got to do your job and to do it well. So I commend you for your service. Grateful that you're willing to do it. If I can ever be of assistance to you, I'd love to. I know you're in great hands with CAMCO, so press on, guys. You're doing great. So
thank you, John, and thank you all for attending. Thank you all for attending. Just to give you a little preview. So this is a legislative year. And so we will, towards the end of the year, we will be having a class as well with a legislative update with amazing speakers like John. We'll put a panel together again for our trade show. So be on the lookout. I know it's only the end of January, but as fast as these days are clicking by, the session will be over in June before we know it, and we'll be getting together. In the meantime, we're going to develop more of these Zoom calls and in-person ones. So as soon as we do, we'll get that information out to your managers to get to you as well. And we appreciate you all being here tonight. Have a wonderful evening.
Thanks,
Thank you.
everybody.
Thank you.
Bye-bye.
Bye.
Thank you.